Wilma Liebman is a member of the NLRB. Did I pronounce your name correctly, madam? Thank you. Who was appointed by President Clinton. Prior to joining the board, she served as Deputy Director of the Federal Mediation and Conciliation Service. And before that, Ms. Liebman served as Special Assistant to the Director of that agency. A Philadelphia native, Ms. Liebman has a BA from Barnard College and a JD from the George Washington University Law Center. Welcome, Member Liebman.
Chairwoman Mary, Ranking Member Isaacson, Chairman Andrews, and Ranking Member Klein, and members of the subcommittees. Thank you for inviting me to testify about the recent decisions of the National Labor Relations Board. And thank you for holding this hearing. For too long, labor law and policy issues have been removed from public discussion. The controversy over the board's recent decisions has had the positive effect of focusing public attention on these issues. They matter to working people, to businesses, and to our economy and society as a whole. I have dissented from many of the board's decisions. Those issued in September are the climax of a trend that is now several years old. The impact on workers' rights has been uniformly negative. Today, fewer workers have fewer rights and weaker remedies under federal labor law. Virtually every recent policy choice made by the board impedes collective bargaining, creates obstacles to union representation, or favors employer interests. The result is a loss of faith in the board and growing disenchantment with the law. Some might say that the current board's decisions simply reflect the typical change of orientation that occurs with every new administration. But something different is going on now. More see change than seesaw, not just tilting the seesaw, but tearing up the playground. It was not surprising, perhaps, when the current board reflexively overruled a series of decisions by the prior Clinton board. But it has also reached back decades, in some cases, to reverse longstanding precedent going to the core values of this statute. The loss of confidence in the board is reflected in our dramatically declining case intake. Increasingly disillusioned, unions have turned away from the board, especially its election machinery. It is a troubling signal when protesters converge on the board and demand that it be closed for renovations. To dismiss this discontent as merely politics is a mistake, if not irresponsible. Time does not permit me to discuss these decisions in any detail. I have tried to do that in my written statement. Nearly all of the significant decisions include dissents, which hopefully speak for themselves. In September, the board issued divided decisions that, among other things, created obstacles for employers and unions who want to establish relationships by means of voluntary recognition, a case, I might add, that cannot be appealed under our statutory scheme to the courts of appeals. The September decisions also made it easier for employers to withdraw recognition from a union without an election, legalized hiring discrimination against some who seek to organize a workforce, made it harder for those who have been unlawfully fired to collect remedial back pay, and allowed employers to file retaliatory lawsuits against unions and employees without fear of being held liable. None of these decisions should have surprised a careful observer of the current board. In my written statement and in a new article in the Berkeley Journal of Employment and Labor Law, I have surveyed the work of the current board, its rulings, and its decision-making process. For people who are committed to the goals of the National Labor Relations Act, it is a troubling story. The board has said for the first time that freedom of choice, which is to say the freedom to reject union representation, prevails in the statutory scheme over promoting collective bargaining. It has taken special care to ensure that employees are free to refrain from union activity and to reject union representation, while showing little concern about the rights of employees to engage in concerted activity, to choose and keep a union, and to be free from anti-union discrimination. And in case after case, it has found that employee statutory rights must yield to countervailing business interests of all sorts, including private property rights, various managerial prerogatives, notions of workplace civility, and employer free speech rights. Under this statute, when policy choices so persistently go this way, we have a problem. In addition, the board has regularly ignored the economic realities of the workplace or the vulnerability of working people. and it has departed from established law without adequate predicate or good reason, as the dissents have argued. Today's labor laws were the product of tremendous struggle. We honor that struggle when we take the act seriously, when we enforce it fairly and thoughtfully, and even when we point out its shortcomings. Certainly, the board operates under significant constraints: a judicial, political, and economic climate indifferent or even hostile to collective bargaining, an arguably antique statute. Still, the board can play a meaningful role in preserving the values of this act and in furthering its aims. Its failure to do even that is a lost opportunity. At a time when union membership is at a historic low point and the earnings gap growing, board decisions threaten to undo the law's assumption about collective action as a means to redress economic inequality. Restoring federal labor law to its intended purposes is obviously no panacea, but it would be a step in the right direction. Thank you, and I would be happy to answer your questions.